Division 1 is now in session.
Please be seated. We're on the record now in case CV150405, National Collegiate Student Loan Trust v. Donna Rand and Thomas Smock et al. This is the time set for oral argument. Counsel, you both have 20 minutes to present your oral argument. Counsel for the appellant, you can reserve some time for rebuttal if you'd like to do so. I just want to remind both of you that these proceedings are recorded, audio and visual. So we'll upload this to our website in a few days, and so that image will be out there. Keep in mind, we've read the briefs, we've discussed the case beforehand, we're very familiar with the issues, and so try to focus your arguments as best you can on edifying us on the things that you really think are the major points in your brief. With that being said, counsel, are you Mr. Richard?
Good morning, Your Honors. Yes, Damien Richard on behalf of the appellant, National Collegiate Student Loan Trust. May it please this honorable court, Section 523A.8 of Title 11 United States Code is self-executing. That is the Supreme Court law announced in Tennessee v. Hood, Tennessee Student Assistant Corporation v. Hood, and that is controlling case law. It's controlling on the Maricopa County Superior Court judgment, which brought us here today. I must debunk this false premise that has brought us here today, and that is the idea that the debt was discharged in this Chapter 7 bankruptcy. It was not. And that ties directly into the self-executing nature of Section 523A8.
But before we get into bankruptcy law, let's talk a little bit about what happened in the trial court. Because the case seems somewhat procedurally bizarre to me. This case was set for trial. Then suddenly there's a ruling on discharge. I am at a loss to find any motion papers by either side presenting statements of fact or legal positions under Rule 56. It doesn't appear that any evidence was taken at trial. Is my impression correct?
I do believe that I agree with the court that there is not much of a record here. But we do know that the defendants in this case presented their Chapter 7 discharge form. And they presented it and argued that their student loan was discharged.
But by what procedural vehicle did they do that? I'm going to give the other side a chance to comment on this too, because it just strikes me that this record is too thin for anyone to have won at this point.
I agree, and I agree that the evidence does not support the judgment that was entered, and appellants are here to ask that this court reverse and remand the case for further proceedings to go to trial on the breach of contract claim. Again, the evidence presented, to the extent that the discharge form was presented, the discharge order.
How was it presented, though? I mean, just sort of handed across the bench like People's Court, or was there a motion?
I wish I was there, Your Honor, and I wasn't, so I can't speak to anything that's outside of the trial transcript. But the trial transcript, you have admissions and you have statements made by the defendants where it suggests that they have presented this discharge order and that Judge Hanna reviewed it. And based on that, entered judgment for the defendants, which we think was erroneous. But you also have admissions in this trial transcript, which I would like to point the court to, where they almost acknowledge that they did it wrong. They didn't go seek the adversary proceeding. They didn't seek the order of dischargeability. And I think that supports reversing and remanding the case for further proceedings, because you do have a trial transcript that does have express admissions that from the defendant saying, hey, we'll go in, we'll get the adversary proceeding. That goes back to 523A8, which requires a adversary proceeding to find for an order of dischargeability. There has to be a bankruptcy court determination, and they did not get that. It's the only mechanism available.
But let's talk about the state court proceedings. What would a remand look like? What's your burden of proof on remand?
just to show that the judgment was entered, it was clearly erroneous.
But was there evidence that this was a student loan? I mean, what was it? The defendants seem to say, no, they're not. You seem to say it is. I looked at the documents that were in the record, but was there any evidence as to whether this was actually a student loan or not?
Plaintiffs' appellants lodged the student loan records with the trial court. And our position is that those were submitted, and those were before Judge Hanna when he entered judgment in this case.
But this is a trial, not a book. The court can't simply have documents and make decisions on their characterization without having some live witness, right?
Well, you had a pro se. You had a pro se defendant who made statements.
Right, but you're the plaintiff.
Correct.
You've got the burden of proof. So let's say you win today and the case is remanded. What do you propose to do at trial, and where do the burdens of proof lie?
Well, at trial, the plaintiff will have to prove up the existence of the debt and the fact that it is a student loan debt.
Okay. And that takes us to the next question, because there's an affirmative defense here of discharge. The discharge is obviously in some fashion before the court. There's a document that is a discharge. At that point, have the defendants met their burden with regard to the affirmative defense, and has the burden shifted to you to prove that this was a student loan, or is it your contention that they bear the burden of proving that it wasn't?
They bear the burden of proving that they have a valid discharge. So in the context of student loans, the discharge they presented was not valid.
Well, you don't dispute that the discharge is valid, you just dispute its scope, right? Something was discharged.
Not the debt that was at issue at the trial court.
You contend that the debt we're talking about today was beyond the scope of the discharge, or do you contend that the whole discharge was just invalid?
Just as to the student loan debt.
Okay.
But in the context of that trial, that was the only debt that was at issue. So to present that Chapter 7 discharge in the affirmative defense of discharge, it was a false statement to the court. It was a false premise.
It may have been an erroneous legal position. I don't think anyone was lying to the court, do you?
Well, I think to use the standard form Chapter 7 discharge without having filed an adversary proceeding or obtained a bankruptcy court determination as to the discharge of student loans, to present that to the trial court judge and say, my student loans are discharged, I think that's a misrepresentation, because it's not. It's not what the document says. And if you can just imagine how many students would flood Maricopa County Superior Court or all state courts with their student loan debt if they can get it simply discharged in a no-asset Chapter 7 case. It's simply not the case. The state court opinions that I cite, mostly in the reply brief but also in the opening brief, are directly on point. They are state court appellate courts interpreting what happened here. You have someone coming in, presenting that defense of discharge with a bare bones Chapter 7 order, but not having gone through the required mechanism of an adversary proceeding. And they all point to reversing and remanding the case.
I guess my point goes really to burden shifting. They present a discharge. The defendants present a discharge. This is a debt. Isn't it then the plaintiff's burden to say, no, this is a student loan debt and therefore not discharged? Don't you have to prove that it was a student loan?
I believe that there's an initial burden that the discharge be valid. And as presented in front of Judge Hanna, the discharge was invalid. It was invalid as to the debt that was at issue in the case.
Except that they contend that this is not a student loan. And so if it's not a student loan, then it would have been discharged. Is that correct? I mean, you obviously you contend that it was a student loan. Their argument is, even on appeal, is that this debt was not a student loan. So I think what Judge Swan is trying to say is they present their discharge, then isn't it up to you to say, yeah, that's a discharge, but not as to this debt because it's a student loan.
Well, if there was a finding by Judge Hanna that this was not a student loan, then that would also be erroneous. And this,
Well, Judge Hanna wasn't in a position to make any findings because he didn't have any evidence, right?
I agree that the evidence does not support the judgment, and that should lead this court to reverse and remand for further proceedings.
As far as I can tell, there is absolutely zero evidence in this record because none was ever introduced under the rules of evidence.
We would submit that the student loan contracts were lodged and before the court.
Lodging isn't the same as admission. People lodge their exhibits before trial all the time. That doesn't mean they're all in.
Like I said, the state appellate courts are in accord. This issue has been presented throughout the country, and every single state appellate court who's considered this issue has reversed and remanded. Page 5 of our reply brief is the Rochlitz case. The discharge defense was determined not to be viable. And that's what I'm asking this court to issue here today, is that, yes, maybe they presented this discharge defense, but it was not a viable defense under the circumstances. The very basics of Chapter 7 have to be known to the Superior Court judge. He has to be able to know that this was not a discharge that applied to the student loan that was at issue. I would ask the court follow the Rochlitz opinion and ruling. On page 6, the following page of our reply in the Taylor case, there's a quote where the Taylor court talks about how we want to assume that this trial judge wanted his judgment to comply with the law, and in this instance it did not. Same analysis here.
Okay. You have a document that on its face kind of looks like a student loan in this case. It hasn't been admitted into evidence. We'll set that problem aside for a second. Let's say that I make a loan to my daughter to help her with her tuition. She signs a promissory note and doesn't pay me. Shocker. And then I want to sue her. She gets a discharge in bankruptcy and lists as a debt her debt to me. There's no indicia externally that that's a student loan. It's just a loan. Who at that point bears the burden of proving whether the discharge applies or not?
Again, if the student loan was made under Section 523(8)(a), which these student loans were, it's self-executing.
What does that mean, though, made under 523(8)(a)?
Well,
Does the document,
in this case,
loan document itself cite that statute?
it does.
Okay.
And the borrower signed directly underneath it, promising not only to pay, but promising that they understand that these are non-dischargeable in bankruptcy.
So that's the argument you would make. That's fine. Who has the burden? I'm still stuck on that question from a while ago. Who has the burden?
The debtor has the burden while they're in the bankruptcy, and if the bankruptcy has already been closed and discharged, they have to reopen it. They have to go back. They have to file that adversary proceeding and get a bankruptcy court determination. The Zeichner case, which is on pages 7 and 8 of the reply brief, talk about this bankruptcy court determination. I think that's the mechanism, the only mechanism that's available for these student loan borrowers to get that Chapter 7 discharge to apply. And there's a threshold, there's the Bruner test, and they have to go through that because that's the only due process that's available to the student loan creditors. There's no requirement for student loan creditors to appear or affirmatively prove the dischargeability of their loans in a standard Chapter 7. And that's in that Zeichner case, it talks about the congressional intent. It cites the congressional hearings where they talked about how this statute is going to be self-executing. You provide student loan credit under this statute, it's automatically non-dischargeable. The burden is on the borrower to go into bankruptcy court and obtain that determination. There's not a single case or statute that goes the other way. I'd like to reserve the remaining portion of my time.
All right, thank you, counsel. All right, counsel for Applee, is it Mr. Young?
May it please the court, my name is Taylor Young, and I represent the appellees in this appeal. I think that both sides in this case would agree that the record is dramatically thin in the case below.
Thin to non-existent. I mean,
is
there any way to defend the conduct of this proceeding under any rule of civil procedure?
Well, we had a pretrial statement. We had I'm reasoning with you a little bit here.
Go ahead.
We had a pretrial statement. We had a trial setting, pretrial statement. We had a trial. We had a hearing that had been designated as a time for trial.
You had an oral argument.
Well, it is true, although there was a witness on the phone, evidently, as evident from the transcript, Your Honor. There was a witness, plaintiffs had a witness on the phone who may have been prepared to testify, evidently was prepared to testify, but his testimony was never called. There was no, after Judge Hanna issued his ruling, there was no offer of proof. There was no objection to the entry of this judgment based on Rule 56 or anything else.
Well, but I guess that's what I'm asking. So Judge Hanna enters a judgment at a trial at which no one testifies, at which no exhibits are entered, at which there is no pending motion for summary judgment. I'm trying to determine what the legal predicate was for him to do anything at all.
Judge Hanna concluded, I think, as you can tell from the ruling and from the transcript, that this was not the appropriate, that essentially he didn't have jurisdiction to determine the main issue in this case, which is whether or not this is a student loan and then subject. Yes. I mean, I don't know how else to say it. My client argued discharge, and again, he was pro se. The other side presented legal argument, and Judge Hanna, as I think is evident from the transcript, in reviewing one of the authorities cited by the other side, discovered the Espinoza authority and read it and issued his ruling.
I've found cases that I find pretty interesting too, but would it be a healthy rule of law for us to affirm a judgment entered in this fashion? Just because the judge finds some authority that seems pretty on point is not grounds to enter a judgment, it seems to me. It seems to me that due process requires at least that there be a motion, at least that there be an opportunity to brief the issue, that there be some factual record made in accordance with the rules. But here, it seems that to an extent, both sides are willing to say, forget about the rules. Let's just focus on the substantive law and see if, in the abstract, the judge was right.
Well, procedurally, Your Honor, I disagree that. Well, let me put it a different way. Due process was not raised by the appellants in this case. They've not argued, and I don't think that under the standard of review that the court should be considering an argument that neither party has briefed or had an opportunity to brief.
The absence of traditional trial conduct was briefed in the appellant's brief. And I believe it was also mentioned in yours.
Oh, it was mentioned. The absence of any actual evidentiary record is mentioned in our brief.
Sure.
Absolutely. And let me, just as a detour, to answer a question about where the discharge documents, the documents from they were attached to the answer. And so that is the way they are in the record, and that is how they were presented to the trial court.
Matters outside the pleadings, attached to the pleadings.
They are court records that could be, which I think the court could judicially notice without converting it into a Rule 56.
Counsel, it almost seems like both lawyers and the court presumed that the facts were undisputed, and it was sort of an undisputed record, and you made legal arguments based on what everyone thought was in the record. Is that how you see the transcript?
Well, I mean, just to be clear, my client below was pro se, wasn't represented. So there's the lawyers for the other side, and the judge may have and the court may have concluded that there was no factual dispute. And that is clear from Judge Hanna's ruling, but it's
That's
not.
to the problem, because what we're hearing today on appeal is that there is a factual dispute. The problem is we can't address that according to the normal means, because typically when we ask ourselves, is there a factual dispute on this record, we have a record designed according to the rules, with statements of fact, with affidavits, with some form of evidence, and here we've got nothing. So the fact that we can sort of infer that people acknowledge that there was a debt taken out at some point, and nobody's really disputing that there was a bankruptcy proceeding, is hardly grounds on which to go entering judgments. What we have, the real issue, I think, in this appeal is whether this was a student loan. Would you agree with that?
I agree with you, Your Honor.
And you say it wasn't?
We say that that's an issue that needs to be resolved by the bankruptcy court, not the state court. We think that is a substantive issue of bankruptcy law that needs to be resolved by the bankruptcy court.
That may be true in some procedural contexts, but here you are, the day of trial. What is the trial court to do? Enter a final judgment in your favor that has res judicata effect? Because if so, what's the point of going to the bankruptcy court? You already won.
No, I think the court issues a judgment dismissing
That's
the complaint.
not what happened here.
I
What you're defending is a judgment in favor of your clients that will forever preclude collection of this debt.
I hear you, Your Honor. I hear you.
And can you defend that?
I can defend it. I can defend it on the grounds that they have not raised due process arguments. They have not, and due process. I mean, due process obviously matters at this level as well. I'm not trying to be combative.
I don't take you that way, and I'm not either. But I guess what concerns me is you say, well, this is a matter for the bankruptcy court, not the state court. But the state court jumped in and precluded any future proceedings. So the bankruptcy court has nothing to do. Anything it does at this point has, if we affirm, anything the bankruptcy does is academic.
The other side certainly could have argued to set aside this judgment on due process grounds. They could have. They filed a motion for reconsideration. They could have filed a motion for new trial, a motion to alter or amend. And they could have argued this on appeal. They haven't. And so it would be my contention that based on the arguments that have been raised on appeal, that there is no grounds to reverse and remand this judgment. The arguments that have been
technical about the appellate procedures, but as permissive as anyone in history on the trial court procedures.
Judge Swan, I'm well aware of who wrote Volk, so I'm not going to. I'm
not suggesting this is a Volk issue. I mean, the term due process, I think, is a way of describing the entire system contemplated by the rules of civil procedure, and I'm not trying to make this into a Volk issue. I'm simply saying that we have before us an appeal that raises a dispute of fact, and we have no record before us that can support either the presence or absence of a dispute of fact, because it seems nobody complied with any rules.
Obviously this wasn't a perfect trial, but I would agree with you that what we have in this record is a complaint and an answer and argument at a trial. We do not have any evidence whatsoever. I can't contend that there was. In fact, we said in our brief, we pointed out that the plaintiffs who bore the burden didn't admit any evidence. They didn't seek to admit any evidence. They didn't file a offer of proof afterwards. When Judge Hanna issued his ruling, they didn't do anything to secure those rights.
So let's say that you're right about your bankruptcy theory, that really this is not a matter for the state court. This has to be decided by the bankruptcy court. Okay, and you may want to proceed to argue that here in a moment. But let's say that you're right about that. Wouldn't then our proper role be to say, you're right, Go forth, this judgment is vacated, find out what the bankruptcy court has to say, and come back to us if you need to.
I'm puzzling through that for a second to see.
Take your time.
Substantive issue regarding bankruptcy law certainly could be decided by the bankruptcy court. They could move. They could file an adversary action in the bankruptcy court to determine the non-dischargeability of this loan.
Or you could file one to determine the dischargeability.
We could file. Absolutely, we could file.
But if that's the appropriate forum, and you may well be right about that, if that's the appropriate forum, isn't the judgment that we're here to talk about today premature?
I have a hard time. Yes. I mean, I don't know how else to puzzle through that, and I'm not interested in saying no when I really mean yes.
Okay, and I appreciate that. And just so you know, the reason that I've been approaching these rule issues is not, again, to try and make this into a case that wasn't argued, a due process case, but to ask ourselves procedurally what needs to happen here to resolve the parties' dispute. And if either side is right about what needs to happen, if this judgment, which was entered, in my view, against the rules, stands as an impediment to the resolution that either of you propose, then isn't our first step to vacate the judgment and allow the proper resolution of the issue?
Your Honor, I guess I would just reiterate that it is. I can't disagree with the logic, but again, these are not the grounds upon which the appeal was taken, and so we are at a bit of a disadvantage. I'm happy to reason with the court, but we're at a bit of a disadvantage to come through this.
I appreciate your willingness to do that and your candor, and I'll let you proceed with your argument.
Well, I don't want to belabor the argument, but our first position before we get to Espinoza, which is the case that Judge Hanna read, and we do think applies here, is the substantive issue about whether or not this was a student loan. And if you read the complaint makes no allegation that it's a student loan anywhere. The complaint simply says it was a loan. It's a very skinny 14-paragraph complaint. The answer denies that it's a student loan and presents reasons, and also affirmatively, again, it's a pro per answer, but I think it affirmatively pleads a defense of discharge. So that is the context in which Judge Hanna had to make his decision. And what Judge Hanna was looking at was, well, you say it isn't a student loan. Whether or not it's a student loan has never been adjudicated by the bankruptcy court. I'm looking at a facially valid discharge order, and I can see that notice was received by the other side. I can see that it's listed here. And I have a party in front of me telling me that it's their position that it isn't a student loan. Why is that the state court's province? And we would submit under Ninth Circuit precedent that it's not. That in fact for Judge Hanna to issue an order that this is a student loan and therefore was not discharged would affect a modification of the terms of this discharge order, and that's not something that the court has the authority to do.
But couldn't your clients have filed an action in bankruptcy court saying that the creditor was violating the discharge order?
Absolutely, and most of the cases that you will read arise in that context, where
because basically, as appellant says, I think you would agree, is if it is a student loan, it was not discharged.
If it was a student loan, whether it was discharged, I still think under Espinoza, there's an argument to say that it, in fact, may have been
Well, okay,
discharged.
let's talk about it. Espinoza
Sure.
was a Chapter 13,
correct.
and this was a Chapter 7. There's a difference between a 7 and a 13.
Totally agree, and we don't contend otherwise.
The reorganization.
Correct.
The creditor in Espinoza had notice from the debtor that he was, that they were only intending on paying the principal and not the interest.
Yes, I agree that the creditor had that notice
Okay.
in Espinoza.
And in this case, the Chapter 7 notice to the creditor says, don't even file a proof of claim because this looks like a no-asset case.
But in Espinoza, that is the exact position that the creditor took in Espinoza, which
Except
was.
that it was a Chapter 13.
I understand, but, Your Honor, but in Espinoza, I'm reading your nonverbal cues, Your Honor. I'm not trying to argue. In Espinoza, they argued the creditors argued we were not required to do anything because under the substantive law.
I agree, but they had, in Espinoza, the big difference between Espinoza in this case is that they did have notice that they were only going to get the principal and not the interest. There is nothing in a Chapter 7 bankruptcy that gives a student loan creditor notice of anything except that they have filed bankruptcy. And the notice also says that student loans are not discharged. And it also said, in this particular case, not to file a proof of claim because it was a no-asset case. This is completely different from Espinoza.
Well, in Espinoza, the original discharge order also said student loans are not being discharged.
I agree, but they made provisions in a Chapter 13 bankruptcy. That is completely different.
Your Honor, I understand. I would say that on the terms of Espinoza, what you're saying is that the notice that the creditors received in Espinoza put them on notice that they couldn't sit on their rights, right? Right?
Right.
That is the same thing, because the reason why they couldn't sit on their rights is because they couldn't rely on the provisions, on the self-executing provisions of 523A8. That's what the Supreme Court says. It says you can't, we're not going to allow you to rely upon that. We agree that the judge should not have entered this order. We agree. But it isn't void.
They had a way to object in Espinoza. They could have objected to the plan, and that's what the Supreme Court said. There's no way for this creditor to have objected in the Chapter 7 plan.
Oh, well, this creditor could have appeared and filed an adversary action if they wanted to.
That is not the burden of the creditor.
I understand that's not, I understand pre-Espinoza, that's not the burden of the creditor. I would submit that in a case here where you have specific notice of a student loan debt, it's included in the amount of liability that's going to be discharged, that Espinoza is on all fours. I am perfectly willing to be wrong about that, but I think that if you read Espinoza, and I didn't mean to suggest you had, Your Honor. I'm sorry. If one reads Espinoza and reads the specific provisions that the court is pointing to, all of the arguments that the other side makes here are about self-executing and their ability to rely, and if those arguments don't fly in Espinoza, then they can't fly in this Chapter 13. I mean, this Chapter 7.
I would say that the difference is because of the two chapters.
Your Honor, I completely agree with you that they are different chapters and that they have different procedures. But at the end, the order of discharge is still a final judgment, and Espinoza should apply. Again, it's not our main argument. It came second for a reason. But nonetheless, we think Espinoza is a grounds to affirm in this case. Unless the court has any further questions. Thank you.
Thank you, counsel. Mr. Richard?
Yes, Your Honor. So Judge Hanna obviously made a conclusion of law. And if that is the case, then the standard of review would be de novo. The questioning seems to suggest that he may have made a finding of fact. If he made a finding of fact, it would be clearly erroneous, but I do not think that the record in this case supports any sort of finding of fact because no evidence was presented. If the if the Chapter 7 discharge was presented, then so were the student loan contracts because both were before the court, both were lodged, both were made a part of the record. They may have not been admitted, but they were there. So if we're going to consider one, we can't not consider the other. But we can also not consider either and say that there was no evidentiary findings of fact, and therefore the judgment cannot stand because it's not based on anything. Nothing supports it.
And if we were to say that, do you agree with your colleague that the appropriate forum for resolution of the factual dispute would be the bankruptcy court? Or do you think that the Superior Court has the power to determine the scope of a discharge?
There's a case that we cite in our opening brief that states that it's an Arizona case that superior courts may entertain the defense of discharge. And I believe it's within the power of the Superior Court to look at a discharge to determine whether or not it's valid. And when you're trying to discharge a student loan, you have to look at whether or not an adversary proceeding was brought and whether there's been a determination in bankruptcy.
There are lots of exceptions to discharge that don't involve student loans, intentional torts, DUI, all sorts of exceptions. In your experience, do the superior courts or the state trial courts typically determine whether those exceptions to discharge apply, or is that referred to the bankruptcy court?
I think it's a case-by-case situation, but the judge has to dig a little deeper and look at the arguments of counsel, look at the facts that are presented. Here we were presented with a judicially noticeable bankruptcy record that had a complete absence of an adversary proceeding. So the judge should have known that this student loan was not discharged. And he was capable of make that determination and realize and rule that that defense was not viable. Again, I point to the state appellate cases. Every single one goes in favor of the appellants, where you're presented with this non-viable defense.
They do on remand.
It gets set for trial. And if the
Superior Court.
That's right.
Or do the appellate decisions you're talking about contemplate further adversary proceedings in the bankruptcy court?
I don't think they can direct and make the argument for the debtor, but the debtor should get smart, reopen their bankruptcy, and file their adversary proceeding. Because that's the only way they're going to get this discharge. And that goes back to Tennessee Student Assistance Corporation v. Hood. The Supreme Court says this is a self-executing statute. And again, if you go to our reply brief in the Zeichner case, it cites the Senate report. 523(8)A is intended to be self-executing, and the lender or institution is not required to file a complaint to determine the non-dischargeability of any student loan. And to go back to Your Honor's earlier point about what if you use the loan for non-education purposes? That's not the burden. If the loan is made under 523(8)A, it's self-executing. The purpose of the loan and not how the funds are used is what determines whether it's an educational or student loan. And there's a lot more law on that. That wasn't an issue in this case.
But that's beyond the scope of what we can resolve today, right? Because we don't have the factual record to even go into that analysis.
I agree with you. But you brought up the analogy of your daughter, and I wanted to respond to it.
Fair enough.
It doesn't matter what she uses the funds for. If you said this is for school and you made that loan under 523(8)A.
My analogy was actually directed more toward what if I was assuming that it was a student loan, it just didn't appear on its face to be a student loan. In that case, it would seem to me if she files bankruptcy, it would be somebody's burden to prove that this ambiguous loan is or is not a student loan. And so my question was really geared at who bears that burden.
It's the debtor's burden, Your Honor. And there's different mechanisms the debtor can use. The primary one is you have to prove undue hardship, but there's others. And when we talked about Espinoza in the Chapter 13 case, you have to present that to the bankruptcy court, and there has to be determination by the bankruptcy court. Here that did not happen, which is why this judgment should be reversed and remanded for further proceedings. Thank you.
All right, thank you, counsel. We'll take this matter under advisement, and we'll issue a written decision. Court's in recess.